Okay, thanks a lot, Neil. I really appreciate that. And hello and good afternoon, evening to everybody who is joining us. I'm going to take you through, as the title suggests here, estate planning basics. Let's get the legal formalities out of the way. I'll give you a second to read through all the disclosures. Now that we're done with that, let's move right on to the heart of the matter and talk about estate planning. One of the big misconceptions regarding estate planning is that it's only meant for wealthy people. And the reality is that even people of modest assets really need to consider estate planning. And we're going to go through what the various tools are and why it's important. But the key thing to keep in mind is that without a plan, you may be leaving your loved ones with the ordeal of trying to settle your estate. It's a very burdensome process that involves a lot of stress, cost, delays, and frustration. And it could be, estate planning could be as easy as just drafting a will, or as complex as establishing several types of trust to serve varying purposes to accomplish what you want to accomplish. So we're going to explore a little bit why you should consider estate planning. And, you know, it is a key component of a financial plan. I'm sure if you're working with GB and his team that you're working there because of the knowledge that they bring you and the help in coordinating an overall financial plan. This is a very key component of it. It's aimed at managing an individual's assets, making sure that those assets are distributed seamlessly, and give some direction for not only when you've passed away, but what most people don't consider is that it also gives direction should you become incapacitated. So without a plan, you know, the main risk that you're running around with really is you have the opportunity right now to reduce or avoid taxes that may be subject to your estate, be able to protect those assets that are left over for your loved ones, and make sure that your wishes are clear. And the big problem here, though, is that without an estate plan, you risk your assets going into probate. And for those of you who aren't familiar, probate is a process in which the court basically supervises, administers, and decides who will receive your assets. And it's all dependent upon various state laws. Each state is a little different, but probate can be a lengthy and costly process. And for example, I'm talking to you here from Scottsdale, Arizona. And in Arizona, if you don't have an estate plan, if you don't have a will, it is basically called dying intestate. And in the state of Arizona, if you die intestate, what it basically says is that the state has a will for you. And in Arizona, if you are a married individual and have children, a third of your estate is paid to your spouse and 2/3 is paid to your children. So you're going to end up with a very angry spouse in Arizona if you don't take care of those things ahead of time, particularly if that's not the way you want your assets distributed. So the big issue with estate planning is making sure who you want to get what gets it and the way you want them to get it. Excuse me. Okay, so it preserves your assets and assures your assets will be managed properly if you were to become disabled. That is a big key. Most people don't take that into consideration when considering estate planning. It'll also help to minimize confusion, avoid conflict amongst family members when it comes to your final wishes, because I've been in the financial services business since 1982. I've been involved in many different settlements of estates, and even the most harmonious families kind of turn each other and can have problems that they didn't expect whenever there's money and property involved. So it's important to do this type of planning ahead of time. Okay, so let's look at some of the tools that you can use. And many estate planning tools available are there to help reduce taxes, transfer costs, and resolve specific estate planning needs. So let's take a look at some of the commonly used tools. The first and most basic, of course, is a will. If you don't have a will, this is at the very least the minimum you should do. I've already explained how the intestate laws work, at least in Arizona. In the state that you're in, they may be different, but it's definitely very clear that each state has an idea in mind of what they're going to do with your assets if you don't tell them what to do with them. So very important that you consider looking at a will. What the will allows you to do, one of the big things is name the executor, and the executor is the person who is going to initiate your requests that you put into that will. Also, if you have minor children, you're able to name a guardian. If you have minor children, could you imagine allowing the court to decide who is going to be the guardian of those children? And it won't always necessarily be a blood relative. Okay. The will also allows you to control the distribution of your assets as far as who gets what. What it will not do is it will not override or interfere with any designated beneficiary arrangements you may have, either on annuities, life insurance, IRAs, etc. And it will not abolish any terms of any trust you've established. So the trust will take precedence. Okay. The risks of not having them, as we've already discussed, the state's going to decide how your property is distributed. You're going to have someone who you don't know acting as your own personal representative, a guardian who you don't know or didn't choose or have a say-so in raising minor children, assets distributed according to your state's law, which is usually not what most people want. Also, the big thing is you could miss a big opportunity for tax savings, and we'll talk about some of the transfer taxes that are involved in selling an estate in just a minute. The other thing that's a real issue, especially if you have minor children or children of age but are very young adults, they may be receiving their inheritances before you'd actually want them to and without conditions. We've seen a number of times 21-year-old young people getting large inheritances, and that never really turns out very well in the long run. Okay, so again, the will is the simplest form of estate planning, the simplest estate planning tool. However, the one thing it does do is it guarantees that your estate is going to end up in probate. So in order to avoid probate entirely, that is where trusts come into play and where they are used. A trust is a legal arrangement involving the transfer of property to a trustee who holds the legal title and manages the property for the benefit of one or more individuals. So trust can be an important element of your estate plan because basically the trust as a legal entity is going to own all the property that you put into it, and then the trustee is going to manage that property, distribute that property according to your wishes. And you can put any type of restrictions on those distributions as you'd like. So for example, if you had a child that was going to be financially supported by this trust from your assets, or any heir for that matter, you may want to make sure that they're living responsibly and require that they meet certain objectives, like maybe graduating college or maintaining a job or something along those lines, before they are to receive any distributions from the trust. So it gives you a way of establishing the ability to avoid probate, provide financial support to loved ones, maintain privacy, because that's the other big thing about probate. Probate is a public event. Anybody can see what is probated. However, a trust is a private entity. Nobody but the trustee and the beneficiaries are going to be privy to what is going on inside of the trust. Okay. The basic breakdown of a trust is you have a grantor, which would be the person who owns the property, who then puts it or titles it into the name of the trust. You have the trust agreement, which dictates how that property is to be managed. And then the trustee, who is ultimately the person who is managing that property for the grantor. And in many cases, if we're using a revocable living trust, the trustee and the grantor are the same person. and then at the time of the grantor or trustee's death, then the successor trustee would step in to fulfill the rest of the requirements and demands of the trust. And then you have the beneficiaries, who are the individuals who receive benefits from the trust and the trust property. Okay. Okay, so there are basically two types of trusts, either a living trust or a testamentary trust. And a living trust is one that is in effect or is effective during your lifetime, but may be revised from time to time until your death or even revoked entirely. A testamentary trust is a trust with provisions that are included in your will and does not become operative until your death when your will is probated by the courts. So again, depending on what you're trying to accomplish here, if part of your goal is to avoid probate and keep the entire process as private as possible, a living trust would probably suit your purpose more. Trusts can also be set up either as revocable or irrevocable. Obviously, if it is revocable, that simply means that the creator, the grantor, can make changes to the trust at any time. If the grantor sets up an irrevocable trust, that simply means that the terms of the trust cannot be changed, and any property titled into the name of the trust is irrevocably given away. So there are appropriate times to use both. The most commonly used tool is a revocable living trust, as I had mentioned earlier. This gives you the ability to still manage those assets that you put into the trust as the trustee of the trust, and then at the time of your death, the successor trustee that you have named takes over the management of the trust assets and follows the instructions within the trust to accomplish whatever goals you had set forth for that person. Okay. So again, summarize some of the benefits are, professional management and investment of trust property. And by the way, property that is put into the trust that is to be invested, the trustee does not necessarily the person who makes the investment decisions. Typically, they do employ a financial planner or investment professional who would advise on proper, investment allocation and so forth. The other benefits of the trust are specific conditions on how and when assets will be distributed. Again, you could put certain conditions on whether or not the beneficiary is going to receive a benefit, whether it be that they have to maintain a job or graduate college, whatever the deal might be. Provisions to help minimize gift and estate taxes. We'll talk about that a little bit more in detail in a minute, but definitely through the use of trusts, we can help minimize these transfer taxes that happen at the time of death, and ease assets to be distributed to beneficiaries. You avoid probate. We don't have to get involved with anything along that line that would make it a little more complicated. There's no fighting over who gets what. It's pretty cut and dry because of the trust statement. And then provide protection for property against any claims from creditors. Using an irrevocable trust, again, you can, because you are irrevocably giving away that property, it is not subject to the claims of your creditors or the creditors of the beneficiaries. Okay. The next tool that you should be aware of is called a durable power of attorney. This is a document that authorizes one or more persons to act on your behalf if you are incapacitated physically or mentally, unable to make these decisions for yourself. So the durable power of attorney document does not govern any medical or health care decisions, but your personal representative would be able to manage such things from a financial nature for you, like taxes, real estate, bank accounts, loans, bills, investments, and so forth. So they're basically making those types of decisions for you if you are incapacitated. Okay. A living will, on the other hand, is a document that expresses your desires and preferences about medical treatment. So while living wills are allowed in all states, certain formalities may apply in order for them to be effective. If valid, a living will binds healthcare providers to its instructions, so they cannot deviate from what you have dictated in the living will. And most common example of this is whether or not you want to be on life support. Many times people will specifically write into their living will that if my only way of maintaining life is through artificial means, then I want to be disconnected from those machines. So you have all these directives already preset, so you don't run into any conflict either with the medical professionals or family members. Another tool is a letter of instruction. This provides information about your estate to your executor in the form that is easily understandable. The most important thing to know about a letter of instruction is that it has no legal authority. Its main purpose is to provide information about your estate to your executor in a more understandable, non-legalese type of statement. So many people find that very helpful. It could contain such things as a list of all your assets, location of important documents, instructions on the distribution of lesser valued possessions, and etc. A nice kind of rounded out list here of some of the other things that wouldn't normally be detailed out in a trust statement or a will, but this letter of instruction you can get very detailed and specific with. Okay. Now, believe it or not, another very useful estate planning tool is life insurance. And most people probably don't think of life insurance as an estate planning tool. They think of it as, the typical uses of life insurance from the standpoint of replacing income or paying off a mortgage. But it plays a very critical role in many estate plans. Everything from helping to offset some of those death transfer taxes that I mentioned, as well as making sure that charitable beneficiaries are taken care of. So life insurance can play a very important role in your overall estate plan depending on its composition. So with life insurance, typically we use a permanent form of life insurance in estate planning. That is because we want the insurance to be sure that the insurance is in force at the time of death. This would keep you from using a term policy that might end prior to a person's life expectancy. And there are many different forms of life insurance that can be used. And again, one of the biggest uses of life insurance in estate planning is to offset the transfer taxes, those including federal estate tax, state estate tax, and income in respect to a decedent, which are all taxes that come into play at the time of a person's death. So that's a perfect segue into the next section, talking about those taxes. And another misconception that sometimes is out there is that with the passage of the American Taxpayers Relief Act of 2012, many people started to assume that estate taxes were no longer a concern for them. So if we review, that act and what it actually did, and some of you may remember the big to-do about this back in 2012 when it was passed. It kind of got passed out of nowhere in the 12th hour, 11th hour of December. And what it did from a federal level is establish a $5 million exemption for estates from the estate tax, and that exemption was also tied to inflation, so it does increase. And in 2014, this year, the total amount of the exemption is $5,340,000. What that means is that the first $5,340,000 of your estate is exempt from estate tax. Anything over and above that could be subject to upwards of 40% on a federal level. However, that is $5,340,000 per person. So if you have a husband and wife, they actually have a total of $10,680,000. In addition, the law included a section called portability. And what portability does is it enables a couple to exempt the $10,680,000 either at the second death So even if it is not taken advantage of by the first death with the 5.3 million, the surviving spouse doesn't lose the deceased spouse's exemption. So with that, when you're talking about a married couple, an estate of anything under that $10.6 million figure is not going to be subject to estate tax. The concern, though, that you have to take a look at is what is valued in that estate. And it includes all property owned by you and your spouse. And even if it doesn't total above the 10.6 million, if your taxable estate is approaching that number, what you have to put into consideration is the growth of that estate going forward. So depending on the makeup of your estate and what assets you have in there and what they're growing at, and in addition, a reasonable expectation of your life expectancy, it could be very possible that over time you do exceed that exemption amount. So again, with the help of a financial planner like someone like GB, you can help project out where that estate may be and whether or not it should be a concern to you. Now, even if the federal tax doesn't seem like it's a concern, we do have a number of states, and District of Columbia and Maryland are two of them, that have their own estate or inheritance tax. And as a matter of fact, Maryland has both an estate tax and an inheritance tax. It's one of only two states that have both. And in this case, even though your net worth or your estate is not subject to federal estate tax, in these states with their own tax, they could very well be subject to that. What's interesting is that in both Maryland and District of Columbia, the exemption amount is only $1 million. So if you have a estate valued at $3 million, you're well below the $5 million and change for the federal level, but you're above the state level, and the additional $2 million that's subject to the state tax could be taxed at as much as 16%. So it's important to take a look at not only where you live, your state of residence, but also where you hold property. Because some of these other states, as you can see here on the map, if you hold property in those states, it could also be subject to estate tax in those states as well. So very important. It's kind of a double-edged sword there. You've got the federal tax and the state tax, and very important to kind of assess what your exposure is, both on the federal and the state level. Another thing to point out is that none of the states have the portability feature that I mentioned on the federal level. So what that means is that if we have a husband and wife, and the husband passes away first, and you don't take advantage of that $1 million exemption, the surviving spouse loses it. So very important to have proper estate planning documents so that you don't pay excess taxes that you don't need to. And again, that's something that GB can help you with. Okay, so getting started, if this is a concern for you, what should you consider? How does the process start? It's very simple. You start with an initial financial advisor like GB who can help put together an estate planning team. And the team typically might include an attorney, of course, maybe an insurance professional or a tax professional, and possibly even a trust officer. But I've worked with GB and his team in this area on a number of cases, and GB's got access to anybody who may be needed as part of your team. The important thing is to start the conversation with him and express what your concerns are and what in this presentation may have caught your attention. Okay. The other thing to consider is an estate plan review. If you've already drawn up documents, if you have a trust, you have a will, if you've done some type of estate planning in the past and it's been more than 2 years, then a review is definitely something that you would benefit from. Some of the reasons that it's important for you to update your estate plan, as we've mentioned here or listed here, the biggest one is the tax law changes. We know that 2 years ago all the laws, the tax laws changed, and as a result, you need to review those documents to see if they are still going to meet your goals based on the new tax laws. Okay. Okay, and with that, I hope that was educational and thought-provoking presentation. Neil, I don't know if you're still there.
I'm here.
Happy,
yes,
yeah.
Thank you very much.
Happy to answer any questions if there are any.
Sure, we'll turn it over to a little bit of Q&A. Thank you, Mike, for that presentation. It was very informative. You went through a couple of key concepts there. Does anybody have a question for Mike or I?
This is Jeff Krause. Can you hear me?
Yes, we can.
Yes.
Hear you, Jeff.
Hi, Jeff.
Our state attorney told us about a month ago that Maryland has just changed its laws regarding the estate taxes. It's complicated. It phases in. It's not as bad as it was, but you know, it would help perhaps if I know the GB has a number of clients who live in Maryland to have a specific program like this on Maryland. Thanks.
Sure. Yeah, we could do that at a future showing. Sure. Just on the Maryland estate tax and inheritance tax program. At what level? You know, you have the exemption and at what rates and so forth and what's included. Sure, we could do that. Any other questions?
Yes, Mike, this is Patrick. I just had a question about the inheritance tax and the estate tax. If we had inherited something, let's say from California, and we live in the district, wouldn't the taxes occur at least from where the property is located?
Oh, wow, that's a great question. And Patrick, unfortunately, I'm not an attorney, so I'm not sure how that would be viewed. My opinion is that the tax is based on the situs of the property. So California doesn't have an inheritance tax or a estate tax. So if that property is California property, I don't believe it would be subject to a Maryland tax, other than possibly the inheritance tax, because that is based on property you receive, not property you own. So unfortunately, I don't have a better answer for you than that.
Okay. Thank you, Mike.
Sure.
Any other questions you guys have?
Yeah, this is Patrick again. I have a second question. In terms of the slides itself, will we have access to those slides? And also, you know, this is something that we probably want to have a conversation about with GB on our next meeting.
Sure. Right. Yes, you will. You will get a transcript of the meeting. WebEx, the technology we're using, sends out an email to you. So you can actually, we've recorded this, so you can go through that, and then also have access to the presentation on this.
Okay, thank you.
No problem.
Hello, this is Nancy.
Hi, Nancy.
Hi. Could you say something more about irrevocability and where it enters in and why it becomes important? You mentioned it at several points during the presentation.
Sure. That was during the when we were differentiating between the different types of trusts. And a trust is either revocable or irrevocable. As the name implies, if it's irrevocable, anything you put into that trust you can never touch again. And you may say, well, gee, why would we do that? You know, I don't want to get rid of my assets while I'm still alive and need them. There's a couple of uses for an irrevocable trust. One is it's completely creditor protected. So if you had an asset that you might be concerned would be subject to maybe a lawsuit, or that you didn't want to lose, should you have a creditor or a lawsuit, you would put it into this irrevocable trust, because again, you don't own it any longer. Now there are certain rules that you have to follow to make sure that is creditor protected. In other words, if you know you're getting sued, and you've been sued, you've been served, and now you try to give all that property into an irrevocable trust, it won't work. If there is a judgment found against you, the judge will pierce the trust and make you pull the property out. So it has to be done prior to any known claim or anything like that. The more common use, something that we use quite regularly with an irrevocable trust, is give you a real basic structure. Let's say we had an individual in Maryland, and they were going to be subject to estate tax, and the estate tax was calculated or projected to be about $400,000. One technique of offsetting that tax is that we would set up an irrevocable trust that would be funded with life insurance. And because that's an irrevocable trust, that life insurance death benefit is outside of your estate. And then you would be able to gift the premium to the irrevocable trust. Then at the time of your death, the trust would take the life insurance death benefit, which it would receive income tax free, and pay the estate tax for your heirs. And in that way, you've offset the estate tax and paid basically pennies on the dollar for the actual tax cost. But that only works using an irrevocable trust, because the irrevocable trust that holds those assets, all those assets are outside of your estate. Being outside of your estate, they're not subject to the estate tax.
You mean because it's life insurance?
No, because it's owned by the irrevocable trust.
I see. Oh, right.
Yeah. If you personally own that $400,000 life insurance policy, then that $400,000 death benefit would be part of your estate.
Right.
And
so
that's
it has to
why
be by the trust.
Yes.
And if you are trying to leave money to a charitable organization or a university, they often ask that a scholarship you set up have some kind of irrevocable a clause as you set it up, so that that money can't just disappear later as your estate gets settled, especially if it's something you establish to have to go on now in the present and then continue afterwards.
Yeah. That's another way that life insurance can be used as an estate planning tool. So let's say that, for example, you had a certain asset that you wanted to leave to the charity as, the funding vehicle for this scholarship, but yet still wanted to pass a certain amount of wealth to your heirs.
Right.
Many times we set up what is known as a wealth replacement trust, which again is an irrevocable trust funded with life insurance, so that your charitable assets would go to the charity, thus reducing your estate to zero or reduced significantly, and then the heirs would inherit the life insurance death benefit, which would go to them both estate and income tax free. Yeah, so we're just scratching the surface on estate planning. A lot of times estate planning also involves charitable planning, and if you're self-employed and own a business, also business continuation planning as well.
Thank you.
You're welcome.
Thanks, Mike. I think we'll set maybe one more question and probably call it a night. I know it's getting kind of late over here on the East Coast. I don't know if everybody has ate their dinner yet, but I have not. Anybody? Okay. All right. Well, obviously, you guys are more than welcome to ask me and GB any questions, anything that you guys didn't get addressed tonight, or anything that you want to particularly ask that is involving your particular situation, you want to do that confidentially, I'll go ahead and just let you know that you're more than welcome to come in and address that with either GB or me. But Mike, I appreciate the time you've given us tonight. It was very informative, and Mike also helps us with a lot of our insurance needs and things like that. He's a very good asset to us, so appreciate it, Mike.
You're welcome. Everybody have a good
All
evening.
right.
Thank you.
Thank you, Mike. Thank you, Mike.
Thank you, Mike.
All right, that concludes
Bye.
our conference tonight. Thank you guys very much, and I'll see you guys in the office shortly, I assume. Thank you.
Thank you.
Good night.